Hi guys, welcome back to my YouTube channel. So my name is Karabo Sitole, and in today's video we are doing business rescue. Welcome to Class of Asymptotes channel, where we do everything accounting science or everything become accounting, whatever, anything accounting related, right? So in today's video we are doing business rescue. If you haven't subscribed, please make sure you click that subscribe button. So as we are saying, we are doing business rescue. So if you look at the term business rescue, right, without even going to the sections and to what the Companies Act says, business rescue. So we are trying to rescue some company that is in trouble. So this company is not able to pay its debts. We say that this company is actually financially distressed, meaning in the next 6 months, this company is not going to be able to pay its debts that are due within the next 6 months. They're not going to be solvent within the next 6 months, meaning their liabilities are going to be greater than their assets, right? So that's what business rescue really is about. It's about the Companies Act giving us guidance on how then do we go about saving this company. What is the procedure to actually now initiating this business rescue proceeding, right? So let's get right into the sections and what the Companies Act says. So obviously we first need to define what exactly business rescue is, and as we always do, we need to look at the section that we start with, and that section is going to give us the definitions. So when we look at business rescue, the section that we start with is section 128, right? And then it will go on and on and on. So section 128 defines business rescue as, and you will see that there are actually three components to this. The first one is the temporary supervision of the company, its management, its affairs, as well as its property, right? So what we are basically saying is that in order to rescue this business, right, we need to hire someone who will temporarily supervise this company, supervise how it is run, the decision that it needs to make, its affairs, its property, right? So that's what business rescue is. It is a temporary supervision of that company, its management, its affairs, its business, as well as its property, right? The second component to what a business rescue is that it is a temporary moratorium on the rights of the claimants. So temporary moratorium on the rights of the claimants against the company. So what we are basically saying here is that we are going to put a hold, right, on the people that can claim from you. So you're not able to pay those people, and under normal circumstances they can actually go to court and claim and take maybe your property, take your cars in order to pay whatever you owe them. But we are saying, because we are trying to save this business, we are going to put a hold on that right that you have to claim against this company. So that's what a business rescue does. The third component of business rescue is that you need to develop some kind of plan, and this plan must be to rescue the company as well as achieve a better return for the company's creditors, such that whatever they are going to get back is better than what they would have gotten back if the company was immediately liquidated. So yeah, what we are basically saying is that a business rescue, right, is the development of a plan in order to save this company, to rescue this company, right, in such a way that the creditors will get a better return, right, than they would have if this company was just closed off and just liquidated. Liquidation means you're selling all the assets of the entity, you are selling all the property of the entity, and you're giving whatever you were able to get to the creditors, to the people that you owe. But we are saying we want to rescue this business, and we're trying to make sure that you get a better value. So say for instance, if it went straight to liquidation, you would have gotten 10 rand. But we are saying if we try and save this company, you'll be able to get 20 rand. So we would rather save this company and put a hold on your rights, allow us to save this company, and as soon as we have saved this company, you can be able to actually get better claim. You can get a better claim, right? So that is how the business rescue thingy is actually defined in section 128 of the Companies Act, right? So we are saying a business rescue plan is not just implemented on any company. It is implemented on a company that is said to be financially distressed. Now we need to look at what financially distressed means, and we already covered that. It is also still under section 128, right? Because we said the first section defines, and the section that initiates this whole business rescue thingy is section 128, right? So section 128 defines a financially distressed company as a company that will reasonably be unable to pay its debts that become liable within the next 6 months. So you're not going to be able to pay your creditors that you need to pay within the next 6 months. And the company is reasonably likely to become insolvent in the next 6 months, meaning your liabilities, your debts are going to be greater than your assets. So you are said to be financially distressed as a company if you won't be able to pay your debts within the next 6 months, and if you are insolvent, meaning if your assets are greater, if your liabilities are greater than your assets, right? Now we have defined what we needed to define. We move on to the next thing. We are saying, okay, we understand that this company is financially distressed and there needs to be some plans to save this company, but how then do we initiate, right, the business rescue plan, right? So we go on to the next section, right? So first section 128, it defines business rescue. Section 129 tells us how then can you initiate this business rescue. So it can actually be brought by the board, right? So section 129 says it can be brought by a board resolution, right? So the board of directors of a company by majority voting may pass a voting when they have reasonable grounds that the company is financially distressed. So meaning that the board of directors is going to have to prove to the courts that this company won't be able to pay its debts that become due in the next 6 months, and that this company is going to be insolvent within the next 6 months. Those are the reasonable grounds that we are talking about. You need to prove to the courts that you are a financially distressed company, right? And they need to file this resolution with the CIPC, right? So once you have filed this resolution with the CIPC, then the business rescue proceedings become effective, right? So once you file, so you want to save this company, you want to go under this process, so you need to file this business rescue with the CIPC, right? And as soon as you have filed this, you need to let the affected persons know, or you need to notify them of the filing within 5 days of the filing. If you fail to do so, the business plan becomes null and void, not voidable, not that you can fix it. Once you fail to notify those people within 5 days, it becomes void, right? And then the company cannot file another business rescue until 3 months have lapsed. So if you fail to notify affected persons within 5 days, your business rescue becomes null and void, meaning you cannot initiate it again, right? You can't rectify it, right? And you cannot file another one within 3 months, right? So you need to wait for 3 months until you file another one, right? And not only that, the company must appoint a business plan practitioner who should meet Section 138 requirements within 5 days of filing the resolution. So you're saying you need to notify people within 5 days, and within 5 days of filing, you need to make sure that you hire a business plan practitioner. Not only that, but you need to make sure that this business plan practitioner meets the requirements in Section 138, right? And we will look at those requirements. The last thing that you need to ensure is that within 5 days after notifying CIPC, so you notify CIPC, then within 5 days after notifying the CIPC, the business plan practitioner and affected persons must be notified. Okay, we already discussed that, right? So yes, let's move on. So we talked of Section 128 defining. Section 129, how can we bring it, right? What is it? How can we initiate it? And we said by board resolution. The next way that you can initiate this is by, let me see. Okay, the next way that you can initiate this is by court order, right? And that is looked at in Section 131. But before we get there, let us look at how they can set this aside, right? So section 130 looks at setting aside of the business rescue plan. So you want to set aside the business rescue plan that was brought by the board, right? So any affected person, we talk of affected persons, but what are they exactly? They are people that are influenced, right, by the fact that this company is distressed. So we're talking of people like your employees, we're talking of people like your creditors, your shareholders. Those are affected people. So whatever decision that you make in this company and the failing or the unfailing of the company is going to greatly affect those people. Those are what we call affected persons. So any affected person can actually come to the court and be like, I don't think there are reasonable grounds for this business plan rescue, right? And they want to set it aside, meaning they want to undo it, right? They want to undo the rescue plan, and maybe they feel like it should just go straight to liquidation. It's just a waste of time and money. Right, so any affected person can come, and we are saying that is covered in section 130. So section 129, the board initiates the business rescue. Section 130, we want to set aside that business rescue, right? And on what grounds can they set it aside? So they can set it aside if they feel like there is no reasonable ground that the company can be saved. So they don't believe that the company can be saved. So business rescue is just a waste of time, right? The company failed to comply with the procedure. So they didn't notify them within 5 days. They didn't hire a practitioner within 5 days and all those requirements. And maybe the practitioner themselves does not meet the requirements of section 138, right? So they can set it aside. Okay, as I was saying, the practitioner does not meet the requirements of section 138, and they can also have an application to actually have the practitioner provide them with security if the business plan fails, right? The business rescue plan fails. But there is one thing that you guys should know, that a director who voted in favor of the business rescue plan resolution may not now apply to the court to set it aside, right? So you can't, because remember we said section 128, the board is gonna take a decision to have the business rescue plan. Now, as a director who voted, right, in favor of that resolution, you cannot now come to the court and be like, I want to set it aside. That makes no sense at all. So the court explicitly says you cannot do that, right? Unless, right, they can prove that they voted due to some information material to that decision that they later found out about but didn't know. So they can come to the court if they say, okay, I didn't know of this material information that influences my decision, right? So I was not made aware of some facts of this business rescue plan, right? So 128 defines 129 board resolution, 130 setting aside. Now 131 bringing the business rescue plan by court order. Right, so for the court order, you are going to the court in order to get the business rescue plan, right? So who can go to the courts? It's obviously not going to be the board of directors, because the board of directors can sit down and decide amongst themselves that they want to have a business rescue plan. So the business rescue plan can be initiated by a court order by an affected person. So a person from outside, a person other than the board of directors, can go to the court and be like, I want to initiate a business rescue plan for this company, right? So once an affected person goes to the court, all affected persons, so all the other people that did not initiate, must then be notified by the company, because there's going to be a court order. The company must now notify these people that there was a business rescue plan that was initiated within 5 days of receiving the court order. So it's 5 days, 5 days, 5 days. Right, and the courts may allow the business rescue plan if it is satisfied that the company is financially distressed. So if you are not financially distressed, if you're going to be able to pay your debts within the next 6 months and you are going to be solvent within the next 6 months, the court is not going to allow that business rescue plan to continue, right? So, and also the company has failed to pay over an amount due to a government authority. So if the company had to, for example, pay SARS and they do not have the money to do so, then the court may actually allow this business rescue plan to continue, right? And if the court believes that it is just and equitable to do so, right? Okay, so we are saying 128 defines The reason why I keep on saying the sections is so that you guys remember in the test. Section 128 defines. Section 129, right, tells us how can it be initiated. And we said it can be initiated by a board resolution. Section 130 tells us an affected person can set it aside. Section 131 tells us it can be brought by a court order, right? And then Section 133 now tells us the first legal consequence of this business rescue coming into play, right? So the legal consequence of this business rescue plan coming into play. And the first one that we look at under Section 133 is a general moratorium, right? So, and we talked about this. We said this is a temporary hold on the rights of the claimants to claim against the company and can only be initiated with the written approval of the business rescue practitioner or by a court order. So we are saying if you want to claim, right, from the company, then you can claim by having a written approval from the business practitioner or by a court order, right? So during business rescue proceedings, no legal proceedings, including enforcement action, may be made against the company or in relation to its property may be commenced except with the written consent of the practitioner. So the practitioner needs to give you permission in order to have any legal proceedings, right, against the company once the business rescue proceedings have been initiated. Or it can be commenced by a court order unless if it's a criminal proceeding against the company. So if the company has some fraud case, some case of stealing, they can commence that legal action even if there's a business rescue proceeding. All right. So criminal proceedings concerning property to which the company is a trustee. So if you guys look at the statement, that property does not belong to the company. It belongs to whoever person, right, that the company is a trustee to. So if this company is a trust company, right, and there is this property that someone wants to initiate legal proceedings against, they can gladly do so because it is not the property of the company, right? So we talked about Section 133. Now, Section 135 talks about the post-commencement finance. Obviously, you're going to need money in order to execute this business rescue plan. And the company, this section tells us that the company may use its assets. So those small assets that you have, you're allowed to use them as security to secure a loan to commence the plan, right? So you are allowed to do that according to Section 135. And then the other legal consequence that we have is the protection of property rights. So the power of the company to deal with its property is restricted and the company may dispose of it, meaning of the property, if any of the following takes place. If it's in the ordinary course of business. So if it's just in your ordinary course of business and you're not just trying to dispose of the property because you want to get some money, right? So if it's in the ordinary course of business, you may dispose of this property. And if it occurs in the transaction of good faith to which the practitioner has given his or her written approval. So if the business is selling this property due to some good faith reason, right? Not because they want to benefit, right? And the practitioner must have given their written approval. Right. So remember we said we remove the power from the management to the practitioner. So whatever you have to do, you have to go through the practitioner and they need to give their written consent, right? Or this property is being sold as part of the business rescue plan, right? What happens to the employment contracts? Nothing, right? They don't get affected. What happens to unpaid salaries before the business rescue plan was initiated? So the unpaid employees actually become preferred unsecured creditors. So they become preferred unsecured creditors, right? Meaning they are going to claim from the company. They are preferred, but they are not secured. So they are first going to pay the preferred secured ones, and they're going to pay the preferred unsecured ones, and then they are going to pay the ones that are not preferred and unsecured, right? And then employees committee. So the business practitioner must hold a meeting with the employees within 10 days of his or her appointment. So we said 5 days for notifying the affected persons. Now we are saying now that the practitioner is here, you need to notify the employees within 10 days, right? What about the shareholders? So there are not going to be any changes to their rights. Shareholders are actually affected persons, as we said, and shareholders may not vote on the business rescue plan, right? They are not going to vote on the business rescue plan. Why? Because they are not creditors. They are equity holders, right? Not creditors. They are not recorded as our liability on our statements, right? And the entity has no obligation to pay them. Right. So what about a director? So a director must continue to perform their duties under the authority. So this is important, under the authority of the business plan practitioner. Right. The director must cooperate with the practitioner and deliver any required books to the practitioner within 5 days of his or her appointment. Right. The practitioner may apply to the court for the removal of a director if the director hinders or fails to comply with the provisions of the act or of the business plan. So what we are saying is the practitioner can actually apply to court to have you removed as a director if you fail, right, to be helpful, or if you hinder or stand in between the practitioner and the plan becoming a success. So they can apply to have you removed. Right. What about the rights of creditors? 2 more pages to go. I know this is long, but this is based on the textbook, not the slides. Right. What about the rights of the creditors? So they have the right to be informed of the business plan proceedings as affected persons. They can form a creditors committee. So each creditor has a voting right, which equals the value of his or her claim against the company, whether secured or unsecured. Right. So you can claim, these creditors have the right to claim the value equal to what they were going to. So they have a voting rights equal to the claim that they had against the company. So whatever the company was owing them, they can claim to that extent. They can vote, to that extent. Right. And then let's talk about the business practitioner. We talked about section 138 and their qualifications. What qualifications are we talking about? What requirements? Right. The first requirement is that this practitioner must be a member of the professional organization as chosen by the minister. So they must fall under some profession, just like how chartered accountants fall under SAICA, right? This practitioner must fall under some professional organization. They must not be disqualified as acting as a director, and this is under section 69, right? They must be independent, section 69, most probably of the Companies Act, right? They must be independent, not be subject to a probation order, right? And yeah, those are the requirements. They must be from a professional organization, not disqualified as a director, be independent, and not be subject to a probation order, right? And then removal. How can we remove this practitioner? We're saying any affected person may apply to the court on grounds of section 139. On the grounds of section 139 to have the practitioner removed, right? Due to what? What grounds are those? That they are incompetent, they are negligent, they perform some illegal acts, and they are unable to perform, right? So those are grounds that an affected person can actually use, right? And then now that you have removed the old practitioner, a new one must be appointed. So a new practitioner must be appointed. If a practitioner dies, if they are removed from office, obviously by the affected person initiating their removal, or if the practitioner themselves resign, right? What are their duties? Duties of the practitioner: they become management, they become an investigator. So they need to investigate what exactly went wrong, how can we fix it, etc. Most importantly, they need to develop a business rescue plan, right? They have all the duties of the directors, right? And they owe the same duties as a director owes to a company, right? And they are paid a tariff as prescribed by the minister, plus any bonus that they were able to negotiate, considering that the business plan becomes a success, right? So let us talk about the plan itself, right? So there are different components to this plan, right? First of all, preparation of the plan. So it is the duty of the practitioner to make the plan, right? Meaning to develop the plan and to consult with creditors and other affected persons and management, right? About the plan that they have made. What are the components of this plan? We need to have the background of this plan. So this plan needs to tell us about the assets and the liabilities of the company. It needs to list secured preferent and unsecured creditors and how they are going to be paid and in what order are they going to be paid, right? The dividends of the creditors, the dividends that the creditors will receive if the liquidation process is commenced, right? The list of issued security holders, so they want to know the shareholders, right? And it must have some information about how much is the practitioner going to be paid. And if you remember, we said they're going to be paid based on a tariff that is decided by the minister, right? The second component of this plan is the proposal. So the proposal should contain details of any moratorium. If you remember what that is, a temporary hold on the rights of claimants. So it should tell us of any holds that you guys put, right, in as a practitioner. It should tell us about the release from payment of debts and which debts are we being released from temporarily, which assets will be used to pay creditors, and in what order, right? And then assumptions and conditions, that's another component. Assumptions needs to tell us the assumptions made, any conditions that need to be met before the plan is put in place, the impacts of the plan itself on employees, when will the plan end, and under what conditions will the plan end, right? And lastly, it needs to end with a certificate. So in the certificate, the business practitioner must tell us that what was in the plan was correct, and it was done in good faith. So it was correct, right? It was correct and it was done in good faith, right? Now the business plan needs to be published within 25 days after the appointment of the practitioner. So meaning the practitioner has only 25 days to do, right, to come up with this plan, have it approved and publish it, right? So yeah, we're almost done, guys. And then meeting to consider the plan, right? They have done the plan. Now we need to make sure that people agree with the plan. So they need to notify people of this meeting within 5 days, meeting of when they are going to decide whether to continue implementing this plan or to amend it, right? So for this plan to be approved, 75% of the value of the creditors must approve of this plan. 50% of those creditors must be independent, right? And no rights of shareholders must have been altered, right? So we're saying 75% of the value of creditors must have approved of the plan. And of those 75%, there must be 50% of them that are independent of the company. And no rights of the shareholders must have been altered, meaning changed, right? And finally, the business plan is implemented. And this should take no longer than 3 months, right? So you will be given 3 months to implement the plan and to see if you can save that business. But if the practitioner sees that they're going to need a bit of time, they can actually apply to the courts to have more time, right? And how can we then terminate? Terminate means bring it to an end, right? After implementing it, bring it to the end. Unlike with setting aside means before it's even implemented, how do we make sure that it's not implemented? Terminated means it was put in place. Now we want to stop that, right? And this is covered by section 132. And this can be done by a court order, right? So that it can be terminated by a court order, or by converting the plan into liquidation. So we see along the way that the plan is not working and we turn that plan into liquidation, right? Or by notice of termination, or if the plan is rejected, right? Okay, summary. Business plan is what we are talking about today, and we said section 128 defines the term business plan and financially distressed, right? And then section 129, commencement by board. Section 130, okay, it's the other way around. It's sorry about that, guys. So it's section 131, set aside. Section 130, okay, by court order, section 131, and then set aside section 130, right? Section 132, we are talking about the plan being terminated. Section 133 talks about the general moratorium of the rules, and then you jump section 134, you go to section 135, which talks about the post-commencement financing, and then we go on to the qualifications of this practitioner. So instead of memorizing the sections, you can actually memorize the order of this. You define first. Okay, know where it starts, right? Starts at 128. You define, you commence. There are 2 ways to commence, by board order or by court, right? Set aside, terminate, then legal consequences, and one of them is general moratorium, then post commandments funds, and then the practitioner themselves, right, is going to be implementing this business plan. And there we talk about their qualifications, which is in section 138. Guys, bye.